31.
Yes, Milaj.
Yes.
Milaj, before I show your lordship what they've recorded in the show cause notice, may I just give a brief background as to what has happened? Milord, on the 31st of December, an alleged incident takes place whereby I am alleged to have done some inappropriate behavior with a minor girl. Post which the family of the victim go to the police station and then they are sent to the all women's police station to register an FIR, which does not get registered on that day. On the following day, on the 1st of January, the BSF issues a order suspending me and thereafter making a staff court of inquiry to look into those allegations. Now, this show cause notice which your lordships are having at page 31, if I may read your lordships. Whereas an FIR was registered against you at All Women's Police Station, Aizawl, PS case number so and so, dated 9th of January, under section 810, read with section 74, 75, subclause 2 of BNS, on allegations of inappropriate physical conduct with a minor girl. Whereas in connection with the above case, you were arrested on 9/1/2026 by AWPS Aizawl and subsequently remanded to judicial custody. Upon completion of investigation, a charge sheet has been filed by the investigation officer before the Honorable Court, Special Judge Aizawl on 5/2/2026, and the case is presently under trial. Whereas the Honorable Court of the Special Judge granted me bail on the 12th of March 2026. Now, your lordships, para 4 onwards is very important. Whereas a staff court of inquiry was conducted under Rule 174 of the BSF rules to investigate into the circumstances of the case, and as per the findings of the SCOI, you have been found blameworthy in respect of the alleged misconduct. My lords, my first contention is that in the show cause notice itself, they give a final finding. It is not a prima facie view. They say that you have been found blameworthy. Now, thereafter, they say, whereas upon consideration of the facts and circumstances of the case, including the findings of the SCI and the nature of allegations, the undersigned is of the opinion that your trial by a security force court is not considered expedient or practicable in the present case. Now, my lords, the finding at para 5 in the show cause notice does not meet the law which is laid down as per Rule 22 of the BSF rules. If I may be permitted to take your lordships to the BSF rules for a moment.
BSF rules 1969.
That's correct.
Rule?
My lords, may straight away come to Rule 22.
Yes.
My lords, I will refer to subclause 2 of Rule 22, which says, when after considering the reports on the misconduct of the person concerned, the competent authority is satisfied that the trial of such a person is inexpedient or impracticable, but is of the opinion that his further retention in service is undesirable, it shall inform him together with all the reports adverse to him, and he shall be called upon to submit in writing his explanation in defense.
Yes.
Now, my lords, what has happened in this instance case is, when the first staff court of inquiry took place, which was constituted,
That is the inquiry contemplated under this 22(1).
that's the inquiry under 174 of the BSF rules.
Okay.
Now, when the first
So, anyway, whatever be the rule, this subsection subclause 2 of Rule 22,
that's correct.
reports on the misconduct and the person concerned. So these reports are generated by this SCOI inquiry,
That's correct, Your Lordship.
right?
The SCOI gives they call on witnesses, they examine them, then I am given a chance to cross-examine and place my defense. Now, interestingly, what has happened in this case, there were two SCOIs which were formed. The first SCOI comes to be formed, if your lordships has page 37 for a moment. The typed copy your lordships would find at page 38, which is the order of the Deputy Inspector General, which details one presiding officer to conduct a one-man SCOI looking into the circumstances of the alleged incident. Now, thereafter, if your lordships has page 46, that is where the first SCOI assembles. Annexure P6, page 46, your lordships.
Yes.
If lordships has the date, it is 2nd of January.
Right.
They form this SCOI, they look into the allegations. Thereafter, I will not bother your lordships with the statements. Now, interestingly, your lordships would directly then jump to page 81, because this is where there has been something which is legally incorrect.
Yes.
Lordships, this is Annexure P16, page 81 is the second SCOI. Now, the second SCOI was conducted because they wanted to rectify certain errors in the first SCOI. No doubt that in the first SCOI, I was given a chance to place my contentions. My statement was recorded. However, in the second SCOI, the department calls certain additional witnesses. And during this period, when the second SCOI came to be conducted between 19 January till 3rd of February, I was in judicial custody. Now, to that extent, your lordship, there has been a violation of Rule 173 of the BSF rules, because that is a mandatory provision. If your lordship kindly has that for a moment.
One
173. Subclause 8. 173 says procedure of court of inquiry.
Yes.
Your lordship, subclause 8, if I may read, it says, before giving an opinion against any person subject to the act, the court will afford that person the opportunity to know all that has been stated against him, cross-examine any witness who have given evidence against him, and make a statement and call witnesses in his defense. Now, this mandatory provision of the rule was violated. That's number one.
So in the second SCOI, you were not granted opportunity.
I was
to
not granted
cross-examine.
opportunity. Now, number two, your lordships, that rule 22 subclause 2 which I showed you, your lordships, that rule mandates that this is a civil offense which is covered under section 46. So, a civil offense as per the BSF Act and the rules has to be tried by a general security force court. Now, if the general security force court would not convene, that satisfaction is recorded under sub rule 2 of rule 22. But a reading of the show cause notice at page 31 indicates that they have not recorded any satisfaction at all. If your lordships has page 31 for a moment again.
Yes.
Para 5, the last line, it simpliciter says the undersigned is of the opinion that your trial by a security force court is not considered expedient or practicable in the present case. They don't say why. Now, interestingly, when the SCOI gets concluded and the findings of the SCOI come, there is a remark by the respondent number 3 at page 96, which says that we will await the outcome of the criminal case, and that is after which we will take disciplinary action. Page 96, your lordships. Para 4. Therefore, final opinion can only be given after disposal of the case by the special judge. Now, my limited case before your lordships is that no doubt that disciplinary proceedings and criminal case can proceed together. But your lordships, the Supreme Court has also held in a judgment which, if I may be permitted to show, please give it. No, go that side and do it. if your lordships has this was a case, your lordships, if I may quickly in 2 sentences summarize the facts. This was a case where a government officer was placed under suspension because there was some gold balls recovered from his premises. Now, what the Supreme Court held here is that the departmental proceedings and criminal proceedings can no doubt be proceeded together because one is based on preponderance of probabilities, the other is beyond reasonable doubt. However, it says that when the charges are serious and grave in nature, it would be but expedient in the interest of justice that the departmental proceedings are stayed. And if the criminal trial takes very long, then the departmental proceedings can resume. In this case, on instructions, I submit your lordships that trial has commenced. 3 witnesses have already been examined. And this show cause notice, if I may put it this way, your lordships, this is a premeditated action because today they asked me for a reply to this show cause notice. But when the show cause notice does not give a prima facie finding but says your conduct has been found to be blameworthy, then your lordships, there are umpteen number of judgments from Oxy Fisheries which clearly say that a show cause notice cannot be an opinion in final because then if I file a reply, the direction for termination would be an empty formality. In the judgment which your lordships are referring to, the lordships may kindly have para 22. 22 is the
Paul Anthony.
Paul Anthony. 22 is the ratio which I have just summarized to your lordship.
Yes.
Well, para 22 Roman 1 says departmental proceedings and proceedings in a criminal case can proceed simultaneously as there is no bar in their being conducted simultaneously, though separately. Roman 2 is important. It says if the departmental proceedings and criminal case are based on identical and similar set of facts and the charge in the criminal case against the delinquent employee is of grave nature, which involves complicated questions of law and fact, it would be desirable to stay the departmental proceedings till the conclusion of the criminal case. Now, this view has been taken by the respondents itself at page 96, where they say we will await the outcome. But without awaiting the outcome, they have now issued me notice under Rule 22, read with 11.2 and 177, saying you show cause as to why you should not be terminated. Roman 5, if your lordships has, in para 22, it says if the criminal case does not proceed or its disposal is being unduly delayed, the departmental proceedings, even if they were stayed on account of the pendency of the criminal case, can be resumed and proceeded with so as to conclude them at an early date, so that if the employee is found not guilty, his honor may be vindicated, and in case he is found guilty, the administration may get rid of him at the earliest. The lordships, I have placed another judgment before Oxy Fisheries.
Yes.
Well, Oxy Fisheries, the question which fell for consideration was that whether the respondents in cancelling the registration certificate in that case acted fairly in compliance with the principles of natural justice. Where if your lordships has
Para?
lordships may kindly have para 23, 23, 24. It says, relying on the underlined portion in the show cause notice, the learned counsel for the appellant urged that even at the stage of the show cause notice, the third respondent has completely made up his mind and reached a definite conclusion about the alleged guilt of the respondent. This has rendered the subsequent proceeding an empty ritual and an idle formality. Now, the finding on this, if your lordships has para 27, para 27, the finding is based on a judgment rendered by Justice S.R. Das, the then Chief Justice, speaking in the Constitution Bench in Khemchand matter. Para 27 says, it is no doubt true that at the stage of show cause notice, the person proceeded against must be told the charges against him so that he can take his defense and prove his innocence. It is obvious that at the stage, the authority issuing charge sheet cannot, instead of telling him the charges, confront him with definite conclusions of his alleged guilt. If that is done, as has been done in this instance case, the entire proceeding initiated by the show cause notice gets vitiated by unfairness and bias, and the subsequent proceedings become an idle ceremony. Well, my case is very identical to what has been opined by the Supreme Court, because at page 31, they clearly say that at para 4, that you have been found blameworthy. Now, this finding, first of all, could not have been given at the stage of show cause notice. Number 2, at para 5, when they say the trial by the security force court is inexpedient, they have not given any reasons for that. Number 3, the second staff court of inquiry proceeds without giving me an opportunity to place my case, so thereby violating Rule 173 subclause 8. On the aspect of violation of Your Lordship's Rule 22.2, there are judgments of the courts. If I may place one judgment. Just give it.
Prior to this page 31 notice, were you given any notice to show cause against the findings?
No.
This, whatever this first SCOI
Because
findings thereof.
yes, the first SCOI happened on the 2nd of January when I was a free man. I was not arrested. During that first SCOI, I did participate. I also gave my statement. However, in the second SCOI, when they examined additional witnesses, which includes the father of the victim, the stepfather of the victim, I was not given a chance. And that the mandatory provision of 173.8 could not be complied with. Thereafter, they themselves give a finding that we will wait for the criminal proceedings to get over and then we will take a call. But they come and issue this show cause notice in a premeditated manner.
Where was that? To await the findings of the criminal court?
It was page 96. Page 96 is Annexure P21, that is the remarks of the Deputy Inspector General on the SCOI regarding the inappropriate behavior with civilian on so and so.
So basically your challenge is twofold. One is that on the basis of Paul Anthony's case, simultaneous proceeding, that is one. And even besides that, the procedure narrative itself is faulty.
That's correct. They have not followed statutory procedure.
Yes,
Because I have
because this-
handed over two other judgments. If your lordships has the judgment of Hemraj, which is by Jammu and Kashmir High Court.
Yes.
Here what had happened, your lordships, the employee, the delinquent employee had overstayed his leave. So that is under a separate provision, 62. If your lordship straight away comes to internal page number 6 of the judgment at para 7, the sub para at para 7, your lordships,
Yes.
it reads Rule 173. It says Rule 173 of the rules deals with the procedure of courts of inquiry and provides a mechanism to be followed in holding of an inquiry into a matter. Subrule 8 of Rule 173 provides that before a court of inquiry gives an opinion against any person subject to the act, the court of inquiry has to afford that person an opportunity to know all that has been stated against him, cross-examine any witness who have given evidence, and make a statement and call witness in his defense. Now, thereafter, it's very important, your lordships. Rule 22 deals with the dismissal and removal of persons other than officers. I'm an under officer. I'm a constable. I'm a leave clerk. on account of misconduct, providing that when it is proposed to terminate the services of a person subject to the act other than an officer, such person has to be given an opportunity by the authority competent to dismiss or remove him to show cause in the manner as specified in subrule 2. Now, subrule 2 contemplates that when, after considering the reports on the misconduct, the competent authority is satisfied that the trial of such person is inexpedient or impracticable, however, is of the opinion that the further retention of such person in service is undesirable, the competent authority has to inform the said person together with all reports adverse to him. The following paragraph reads, it is significant to note here that subrule 2, while making reference to the trial of such person, essentially refers to the provisions of section 19 of the act, which provides that the person, this is again applicable to the facts of that case. In my case, rule 46 and 47 clearly say that I should be tried by a security force court. I apologize, your lordships, it's section 46 and 47.
Of the act.
Of the act. Section 46, 47 read together with rule 47. If I may quickly show your lordships those provisions.
Yes, firstly.
46 of the act, civil offences. Your lordships has 46?
Yes.
It says, subject to the provision of 47, any person subject to the act who at any place in or beyond India commits any civil offence shall be deemed to be guilty of an offence against this act, and if charged therewith under this section shall be liable to be tried by a security force court on conviction be publishable as follows, that is to say A and B, which is not relevant. Thereafter, 47 says, a person subject to this act who commits an offence of murder, culpable homicide not amounting to murder against, or of rape in relation to a person not subject to this act shall not be deemed to be guilty of an offence against this act and shall not be tried by a security force court unless he commits any of the said offence. I fall under subroman A. I was on active duty. Now, if your lordships has rule 47 for a moment,
So 47 is only in relation to murder and rape.
that's correct. That's why I indicated if your lordships has rule 47. Section 47 is one, which I wanted to show that I was on active duty. Rule 47
Yes.
May I read your lordships? Rule 47 says charges not to be dealt with summarily. Charges not to be dealt with summarily. A charge for an offence under section 14, 15 or subclause or clauses A, B of 16 or 17 or clause A of 18 or clause A of 20 or clause A of 24 or section 46. This is where I fall. Section 46 is applicable to me because civil offence is defined as an offence which is triable by a criminal court. Other than that, for simple hurt or theft, or a charge for abatement of or an attempt to commit any of these offences shall not be dealt with summarily. So ideally, they could not have not constituted a general security force court because that is what the rule and the statute provides. Assuming that they chose not to constitute the GFSC, even then your lordships, they should have recorded reasons at para 4 and 5, para 5 as to why it was expedient inexpedient for conducting such a process, which has not been done. My limited prayer today is, Your Honor, that this show cause notice may be stayed, as otherwise it becomes an empty formality, because they have already taken a view.
Yes. What is this other judgment?
Lordships, that is a judgment passed by the Delhi High Court. Your Lordships are having a look at M.K. Singh.
Yes.
Yes, M.K. Singh is another judgment of the Delhi High Court on the same proposition, where if your Lordship straight away comes to para 7, it says, we therefore hold in favor of the petitioner on the sole ground that the dispensation with the requirement of the General Security Force Court under Rule 22 subclause 3, which enables the respondent to dispense with the requirement of holding a GFSC, has been invoked without any reason for regarding the holding of a GFSC as inexpedient, and therefore that order was quashed. This judgment draws strength from a judgment passed by the Supreme Court in Tulsi Ram Patil, which is a constitution bench judgment, Your Lordships, where the rigors of Article 311 subclause 2 was tested.
So at least for now, this MK Singh appears to cover your case on one aspect at least.
That's correct.
What about UI? No standing counsel here. BSF is represented by whom? Otherwise, you served copy on anybody?
Yes. Yes, Your Lordships, we've served.
Who is that? Who they have served copy upon?
Have to give me a petition copy. BSF. Let me see one of the petition copy.
No, this undertaking is there, but is there any central government standing council present in this court? No.
My lord,
In
I
Aizawl.
can accept notice on behalf of all the respondent. Then opportunity of being heard may be given before stay.
You can appear.
Yes, my lord.
What is the date up to which you have been?
4th of July is the,
4th of July.
it would be 3rd, Your Lordship. So that is the reason I'm seeking a stay of the show cause notice at this stage. Page 32 at para 7.
52 para. Within 30 days. So that will be
3rd of July.
I don't think you'll be able to get any instructions within
Yes,
these
my lord.
2-3 days.
My lord, I'll accept this on their behalf. However, kindly give me opportunity of being heard, and I may take instruction in the meantime.
No, you can definitely take instructions, but this by the time you get it, this his time will expire. Red Hat, Mr. Learned Counsel for the petitioner. This is an application under Article 226 of the Constitution of India, challenging, filed by the instant petitioner, challenging a letter of suspension, a letter of challenging a show cause notice dated. See page 2, first cause title. Okay. Miss so and so accepts notice on behalf of all the respondents. Extra copies be served upon her during the course of the day. No formal notice is required. It is submitted on behalf of the petitioner that the petitioner is required to submit his reply to the impugned show cause notice by 3rd of July 2026. Full stop. As the notice itself proposes dismissal from service, the petitioner would be gravely prejudiced unless interim protection is granted. Para. It is submitted by learned counsel for the petitioner that the impugned show cause notice has been issued in violation of the provisions of section 46 and 46 of the BSF Act, read with Rule 47 of the BSF rules, as well as in violation of Rule 173 within bracket 8 of the said rules. Inasmuch as a bare perusal of the impugned notice would show that the authorities are proceeding in a predetermined manner, and the show cause notice is just an empty formality. Full stop. Relying upon the decision of the Honorable Apex Court in M. Paul Anthony versus Bharat Gold Mines Limited, 1999, 3 SCC 679. It is submitted that in view of the pendency of a criminal case containing grave charges against the petitioner, the departmental proceeding ought not to have been continued against the petitioner, and the result of the trial ought to have been awaited. Learned Counsel has also referred to the decision of the Apex Court in Oryx Fisheries Private Limited versus Union of India and others, 2010 13 SCC 427, in support of his arguments. Para, a perusal of the impugned show cause notice ex facie reveals that the concerned authority has decided to dispense with a trial by a security force court, as the same is not considered expedient or practicable in the present case, but no reason as such has been recorded as to why the concerned authority has formed the said opinion. Para. It has been held by the Honorable Apex Court in Tulsiram, Union of India versus Tulsiram Patel, 1985, 3 SCC 398, that while the competent authority can dispense with an inquiry if it is not reasonably practicable, that view should be grounded on reasons. Full stop. Para, having regard to the above, I am of the view that a case for interim protection has been made out in the instant case. Accordingly, the impugned show cause notice dated 4/6/2026 issued by the respondent number 4 to the petitioner. It's at page 31, okay, give the memo number and is stayed till the next returnable date. Learned counsel for the respondents may obtain instructions in the meantime. Full stop. Para. When?
My lord, a copy of the writ petition may be
Yes,
shared.
we have already directed
Yes,
that.
we'll serve them during the course of.
Up to 4 weeks.
Yes, my lord, 4 weeks maybe.
To give a date up to 4 weeks.
37. Daily list for admission, item number 1.
May I please your lordship, I'm appearing on behalf of respondent number 2. I will file my vacalate during course of the day, my lord.
Both the respondent are represented today, my lord.
Both.
Yes.
All right. Hard learned, Mr. Learned counsel for the petitioner. Mr. So-and-so enters the appearance for respondent number
True.
2. One is,
Yes, Lordship, I've already represented.
okay. Respondent number 1 is already represented. Wakalatnama will be filed on behalf of respondent number 2 during the course of the day. So you can admit this appeal today
Yes, my lord.
and call for the TCR.
Yes, my lord.
Appeal is admitted, call for the TCR. Raise the matter again on, yeah.
My lord, we have to frame a substantial question of law. We have proposed that at page 34.
This is against what, workmen's?
No, this EC case, employees compensation.
Employees compensation.
Yes, we have to frame a substantial question of law.
Oh, okay. Yes, yeah.
Page 34 of my appeal, my lord.
So many.
Only for my lord. Our case is that merely non-signing of the deposition form would not render the evidence void, which was accepted by the learned commissioner.
D is not required, I think. That will follow.
Yes, ma'am.
If these are any of, you have to succeed on any of the first three grounds.
Correct, correct. So we have to frame this substantial question of law before the appeal is admitted.
Okay, so we'll have A, B, and C. D is not necessary. It's whether it's perverse, that will be every
Yes.
case. It's not a question of
The-
law, basically.
The other three would be the substantial question.
Yes. Appeal is admitted on the following substantial questions of law, page 34, A, B, C. Okay. Further, additional substantial question of law may be formulated in due course if necessary.
Lordship may kindly give us a fixed date,
Yes.
21/7.
21/7. Obliged.
Item number 2.
It is to be inside. Yes.
Lordship, we are directed to take first steps upon respondent number 2 by way of dusty service, but my lord, due to some inadvertence, we did not take the step, so if you may be allowed to.
Learned counsel for the petitioner prays for further time to take note. Serve notice upon the respondent number 2 by dusty mode. Last that also same thing.
Yes, my lord. My lord, and we will obtain some correct address of the respondent number 2.
It is submitted that the same could not be done earlier due to non-availability of correct address of the said respondent. Prayer is allowed. List again on
I'm appealing on behalf of respondent number 1, my lord.
Mr. So-and-so appears for.
17/7.
Obliged.
Item number 3.
Lordship, due to technical reason, our vocal number is not accepted by registry. So if I may be allowed, if I may be given 4 times to file a fresh vocal number.
And what is your difficulty in submitting the Vagalanama? Last 2 occasions you could not.
Yeah. In the previous court date, 11, we tried to submit it, and there is some technical error, and the registry, yeah, it was rejected. So we are seeking afresh. And it was sent by post and it didn't reach right now.
Third learned counsel for the petitioner, Mr. So and so, submits that he is appearing for respondent number,
All the respondent.
all the respondents, but
One to
the Wakalatnama is yet to be submitted. It appears that, full stop, it appears that on earlier two occasions, Wakalatnama has not been submitted. Full stop, today it is submitted by said learned counsel that the Wakalatnama has been sent by post, which has not been received by learned counsel till today. 2 weeks further time is granted to file Wakalatnama. List again.
Right, my lord.
Obliged, my lord.
16.7. Item number 4.
My appreciate lordship. My lord, there are two respondents in this case. Respondent number 2 is already represented. But however, so far as the respondent number 1 is concerned, despite receipt of the ID card signed on 22nd of April, the respondent number 1 is still unrepresented. And my lord, in the meantime, the TCR may be called for.
Any other respondent?
Respondent number 2 is already presented. As for the respondent number 1, my lord, notice may be deemed served upon him, as ID card was already returned on 22nd of April, as indicated in the office note dated 24/6.
Third learned counsel for the petitioner, as per office note dated 24/6/2026, duly signed AD card in respect of respondent number 1 has been received back on 22/04/2026. However, none appears for the said respondent. Other respondents are already represented.
Lordship, I am appearing on behalf of the respondent number 2.
Okay. So and so appears for only 2 respondents.
Only 2 respondents.
Hence, the petition case will proceed ex parte against the respondent number 1. List the matter from. We can admit it then.
Yes, my lord.
TCR is required.
Yes, my lord. It may be called for.
Appeal is admitted for hearing. Call for the TCR. List the matter again on for orders.
27. Item number 5.
Deeply obliged.
Your Lordship, I am appearing on behalf of the state respondents, number 1 to 5. If I may be given another 2 weeks' time to file my affidavit in opposition. Your Lordship, it's almost...
7, 8, 9 have filed affidavit in opposition.
For respondent number 6, we will not be filing affidavit.
Right, heard learned counsel for the
My lord, may I please your lordship, I'm for respondent number 10 and 11. We'll be filing our affidavit of opposition today itself.
Right.
A private respondent, my lord.
Okay. So all have appeared.
Yes, Lordship.
Who is 11? You're
My
not for
lord,
11.
I'm for respondent 10 and 11.
10 and 11.
Yes, my lord.
Okay. And who is for 4?
Lordship, I will be appearing on behalf of the respondent number 4 as well. 1 to 3,
Okay.
4 and 5.
Means so and so appears for respondents number 4.
1 to 5. 1, 2,
Okay,
3,
1 to
4,
5.
and 5.
Okay, 1 to 5. And then 6. Miss so and so appears for respondent number 6. So and so for 7 to 9. And you are
Mr. David Alompia for respondent number 10 and 11.
10 and 11. Service on all respondents are therefore complete. Learned counsel appearing for the aforesaid respondents. Except for respondents number 7, 8 and 9, pray for further. Pray for how many? 2 weeks.
Look, my lord will be filing it today itself. Possible.
Prays for time to file affidavit in opposition. Prayer is allowed. Affidavit has already been filed on behalf of respondents 7, 8 and 9. So this is the matter again on
16.7. Item number 7 to 8.
My lord, this morning I have filed my written objection in IA 105 of 2026 against the application for condonation of delay on behalf of the respondent number 1.
any other respondents? Two to 4. All right. Yes, what is the delay? How many days?
My lord, 97 days delay, man.
97 days. Okay. What is the reason shown?
My lords, I've enumerated the reasons in para 2 onwards, my lord, from page 3 of my application. It's mainly for seeking legal advice and due to financial constraint, my lord. The applicants have approached the High Court Legal Services Committee, and I was appointed as a legal aid counsel. And thereafter, I had taken steps for obtaining the certified true copy and for preparing the memo of appeal and the stay application as well, my lords.
Objection is on record.
Not yet. This morning only I have filed, my lord. We can have it on some other day, if your lordship permits.
You're seriously objecting?
Yes. Let it be on record having
Huh?
the same. Since I have already filed, my lord, let it be on record.
You have a copy?
I have only one copy. I have served to them.
Huh?
I have served a copy to the respective councils.
Yes, what have you stated? Let's see, give us one copy. Get that? Yes, file, get it.
And
Yes, what is your objection?
yes, my lord, the impugned order was
Oh my God, your objection is even longer than their application.
the impugned order was passed on 18/9/2025, my lord, and as submitted by my learned friend, my lord, due to some financial constraint as stated by them, they have seek for granting of legal aid counsel from the High Court Legal Service Committee, on which they have appointed the present applicant's counsel on 7/11/2025. But my lord, even after the appointment was given, my lord, the applicant had deliberately failed to take any active steps in approaching meeting his counsel, which they met only on 3rd week of November 2025. That is after a lapse of 2 weeks from appointment of the present applicant's counsel, my lord. And moreover, my lord, at para 7 of my opposition written objection, I have stated that at para 7 of my written objection, my lord, they have raised some incomplete certified copy which they have earlier seek, my lord, but they have no documents to substantiate these averments that their earlier applications of the certified copy was incomplete or not.
What
Their-
documentary evidence can they give on that?
by if they enclose any defect certified copy which they have provided earlier, my lord, they can ascertain it by way of that, by enclosing the said documents, my lord. But without enclosing any documents, my lord, they have making these evasive statements in the application for condonation of delay. And even after the legal aid counsel was appointed, my lord, they have not taken prompt steps, active steps in pursuing the present appeal and the present IA, my lord. So the reasons explanation given by them in the application does not amount to sufficient reasons under Section 5 of the Limitation Act.
Yes, very good effort. Had and counsel for the legal aid counsel representing the applicant, appellant,
Applicants, my lord.
applicants, and Mr. Central Learned Counsel for the respondents.
Number one,
Huh?
respondent number one.
Respondent number 1, Miss so and so appears for respondent number 2, 3, and 4. This IA has been preferred, seeking condonation of delay of 97 days in preferring the connected appeal against the impugned judgment dated so and so constitute. An objection has been filed on behalf of the respondent number 1, learned counsel for respondent number 2, 3, and 4 submits that she has no objection to the condonation of the delay para on perusal of the it appears that in substance the applicants were prevented from approaching the court because of time taken up in legal consultations and also due to financial constraints. Full stop. It appears that the applicants had to seek the help of the High Court Legal Services Committee, and legal aid counsel has been appointed to represent them. Full stop. In the objection filed on behalf of the respondent number 1, it is stated, inter alia, that the petitioners, applicants have not been able to provide sufficient explanation for the delay in obtaining certified copies as well as making legal consultations. Full stop. Para. Upon perusal of the pleadings of the parties and upon hearing learned counsel for the parties, I am of the view that the delay of 97 days has been sufficiently explained. Accordingly, the aforesaid delay stands condoned and I stands allowed. Registry is directed, or it's already registered.
My lord,
Is the connected appeal for admission.
27.
my lord, sir, if possible, if it can be taken up on the 28th, 2020.
Atira. 27.
Oblige, my lord.
Item number 9.
May I please, Your Lordship? Lordship, as per the office note 24-6, the service upon respondent number 4 to 6 are still awaited.
My lord, the present appeal pertains to the quantum of compensation to be paid to the claimants. And these
You are for?
I am for the claimants, my lord. I am for
Respondent number
respondent number 1, 2, and 3.
1, 2, and 3,
Yes, my lord.
or up to 6.
Yes, Lordship.
And these other respondents who are not represented were the owners of the vehicle.
You should correct your wakalatnama.
Pardon,
Say
my
1 to 6.
Oh. I'm so sorry, my lord. It should be 1, 2, 3.
Yes, only 3 signatures are there.
Yes.
Yes, what is your submission?
My lord, the appeal pertains to the quantum of compensation to be paid to the respondent number 1, 2, and 3. This respondent number 4, 5, and 6 are the drivers and the owners of the vehicles. So their presence may not be required for disposing of the appeal, my lord.
Yes.
Yes, my lord. Lordship, in the next court date, if they are not being represented, then if Lordship permits, then
And the TCR has arrived, my lord, so paper book can be prepared also, my lord.
So liability has been settled on the insurance company, isn't it?
Insurance company, and they have already paid 50% of my lord.
So this is, you want to reduce the quantum only.
Yes, Lordship.
So what will the driver and owner and all will do here? You are only increasing your own cost by taking steps on unnecessary parties.
Yes, my lord, in the meantime, if paper book may be prepared.
Paper book is required for this MSc appeal.
It might, because my lord, they are disputing contributory negligence, so evidence will
That's
have to
all
be
right.
appreciated.
She is submitting regarding paper book, is it?
Yes, Lordship.
If I have heard correctly. Unless the registry has nothing better to do. TCR has been received already.
Yes, Lordship.
No need to make paper book.
Okay, my lord.
Waste of paper. And good. Only on quantum is there. Will hardly read counsel for the appellant insurance company. Mr. So-and-so appears for respondents number 1, 2, and 3. Only. Notice on respondent number 4 to 6 are still awaited. One is the owner
Yes, Lordship.
and one is driver. Who is the third?
Third is also the owner. Respondent number 4 and 6 are the owner of the truck, and 5 is the driver.
Okay, joint owners. The present appeal is only on the quantum of the award and the liability for satisfying the award is on the insurance company, which is not disputed. Hence, the respondents number 4 and 6, that is the owners of the offending vehicle, and respondent number 5, that is the driver, are not necessary parties in the present appeal. Accordingly, their names be struck off. TCR has already been received. Has it been admitted? Yes, it is already admitted. Lays the matter for hearing. So it's
23-7.
Obliged, my lord.
Branch.
Item number 10.
May I please, Your Lordship, that this appeal is against the order passed by the Civil Judge Senior Division 3, Aizawl District in airship application number 1029 of 2025. If I may take you to page number, which is the relevant
it's
order.
come up for the first time.
No.
No, my lord, sir.
In the previous court, my learned friend has raised that whether this appeal was maintainable under Order 41, read with Section 96 of CPC, which are against a decree passed by the learned trial court. So, my lord, as my learned friend has raised regarding the decree and all, so for this, I come up with the definition of decree, section 2, clause 2, if I may take it to CPC. My lord, in the main order, the main content is after submission of written objection by the opposite parties, it was
Where is it anywhere recorded in any previous order regarding question of maintainability?
previous order is on dated
Acha, yes.
23. My lord,
In fact, I think there are many RFAs pending in this court against these ASIP applications
Yes, my lord.
certificates.
Yes,
So
my lord.
that also, that question bothered me also, but since nobody had raised it earlier,
what our main point is, my lord, that we are not given any reasonable opportunity to counter the written objection which they have submitted by the opposite parties in the lower court.
no, that is true. But now the question is about maintainability,
Yes, my lord.
is it not?
Yes. So for that maintainability, my lord, the
The question is an order for issuance of the ASIP certificate a decree or not?
yes, my lord.
Is it not?
Yes, for that one, my lord, as per section 2, clause 2 of CPC, a decree, there is an explanation, okay, if I may read out. Decree means a formal expression of an adjudication which so far as regards the court expressing it conclusively determines the rights of the parties with regard to all or any other matters in controversy in the suit and may be either preliminary or final. It shall be deemed to include the rejection of the plaint. Here it clearly says that rejection of the plaint. So in the order itself, it clearly mentioned that the instant application is hereby rejected.
But the appeal is already admitted
Yes,
by
ma'am.
order dated 9/2/26.
My lord.
So you have to decide this question at the hearing only. That can be one of the points for determination.
My lord.
And anyway, it is a matter of importance that will have ramifications all over. So I don't think we should dispose of this in a
Yes, my lord.
summary manner in a
Yes, ma'am.
short hearing. Right? Already heard learned counsel for the petitioner, appellant, and learned counsel for respondent. On the last date, a question had arisen as to the maintainability of the instant appeal, as the impugned order passed by the learned civil judge, senior division number 3, ISOL, in ASIP certificate application number 1029/2025 is not a decree, whereas the present appeal is preferred under order 41 read with section 96 CPC, which can be preferred only against a decree. Full stop. It appears that by order dated 9/2/2026, the appeal has already been admitted. Hence, the aforesaid question is to be determined at the final hearing. So this year received.
Yes, my lord.
This year has already been received. Place the matter for hearing on
27/7.
Much obliged.
Item number
My lord,
11 to 12.
If I may, my lord, I have some prior commitment on the 27, my lord. If it
Give a fix.
On the
Agree.
28th, if possible.
28.
Obligement.
No problem.
Item number 11 to 12.
My lord, in this case, the respondent is represented today.
My lord, I have instructions to appear on behalf of the respondent, and I will be filing my parole within a week, my lord. And I further pray 4 weeks' time to file my objection to the IA, my lord.
IA 14 is for condonation in filing the special leave, my lord. And IA 13 is for the special leave.
Just for the sake of clarification, my lord, in this IA 13 and 14, in both of them notice
We
were
have to
issued.
take up the condonation first, isn't
Yes,
it?
yes, exactly, my lord.
That is IA
14.
IA 14.
14.
In fact, it should be registered as IA 13, this condonation.
There is one IA 13.
Yes, my lord, this IA 13 has to be disposed after disposal of condonation. So according to us, it has to be IA 13. It has to be registered, I think. Otherwise, unless this condonation application is granted, the special leave cannot be taken.
So it
Let
should have
the,
been.
let the registry be directed to.
No, is that possible now after registration with system and all? We can't do that.
If it's not possible, then it's okay, my lord.
Anyhow,
Okay,
IA
so
14
Let
has to
it be,
be.
that's not quibble over 13, 14.
Yes, yes, my lord.
What
Anyhow,
matters
IA
is what
14
we
has to
take
be
up first.
taken
Yes,
up
my
first.
lord.
Yes, yes, yes.
14. I'd learn it counsel for the petitioner, Mr. So and so enters appearance for the sole respondent.
My lord.
Respondent, it is submitted that Wakalatnama will be submitted today
Within a week, my lord.
within a week. Full stop further. Time is also sought for filing objection to the instant I. Hence, please the matter again on when
After 4 weeks, my lord.
you did it. In the meantime, objection will be filed at least 3 days before the next date fixed with copy to the.
My lord,
37.
small request, my lord. Just below my name, the registry may be directed to mention the special PP Mizoram Lokaita. Just below my name.
Show the name of Mr. So as special PP in the petitioner
below.
column.
Obliged, my lord.
Obliged, my lord.
Item number 13.
Yes, Your Lordship, this is a bail application. However, I'm sorry to say that the scanned copy of the TCR has not been received by me, and I couldn't produce today.
My lord, previously their co-accused named Kaimul Barbuya was also released by this honorable court by order dated 5 of 6, 2026 in bail application number 36 of 2026. And Your Lordship, it's at Annexure 3, page number 50. And also, Your Lordship, the present petitioners are also his co-accused.
Where is the case diary coming from?
Your Lordship, this previous order is a different case. Actually, they are not filed in the same.
No, where is the case diary coming from?
From Ngopa village, Ngopa police station.
It's within Aizawl.
No, it's outside Aizawl.
So pick up the phone, get to him, have it by day after tomorrow.
Yes, Your Lordship.
All right. Heard learned counsel for the petitioner. Learned if he submits that CD has not yet been received. It is submitted that the case diary stroke scan copy thereof will be submitted. On 1st of July. List again on 1st of July.
Item number 15.
May it please Your Lordship, this is bail application filed under Section 483 with Section 37 of Indian PS Act. And Your Lordship, the prefix of the case is that on 6th of March 2026 at 5 p.m., 13.119 kgs of suspected methamphetamine from Tata Maxi Cab were seized at Zemabok, and in connection with the seizure of the said suspected methamphetamine, the sender named Mr. Thang Tin Kapa was arrested, and during interrogation, he stated that the seized contraband article was to be delivered to Mr. Samsul Haq, which is the present petitioner, and they were formally arrested on 6th of March 2026. And Your Lordship, my main grounds is that there's a violation of Section 47 and 48 of the BNSS. And Your Lordship, this case is currently non-charge-sheeted.
Is commercial quantity?
Yes, Your Lordship.
Yes, when?
Yes, Your Lordship, if this matter may be listed after vacation so that I can call for this case diary. And this is the first time it is listed. And if notice may be issued.
Already heard learned counsel for the petitioner and learned additional PP. This is an application under 483 of the BNSS for grant of bail to the petitioner who has been arrested on the charge of arrested under section 22C of the NDPS Act. Call for the case diary. List the matter again on immediately after vacation.
Yes, Your Lordship.
Immediately.
14-7.
Metro Black.
Why do you file this case read with section 37? Is 37 an enabling provision?
Yes, Your
for
Lordship,
grant of bail?
as it is a commercial quantity.
It's a bar to grant of bail. Should you mention that it is filed under 37? By that you are admitting that this bar is attracted. Is it not?
Yes, sir.
I have seen this practice here only, nowhere else.
Part 2 hearing list item number 1.
Yes, you're referring to the FIR.
Yes, my lord. May I proceed with reading the same, my lord?
Yes, where is that?
Page 2 of the paper book.
Yes.
Sir, I request you to kindly consider the issue brought before you by me and thereby